Hearing in the appeal O'Brien against the Ministry of Justice.
Mr. Allen, before you begin, I think I should say that most of us in this court have been at one time part-time judges paid on a daily fee basis, and indeed we're all judges and therefore have, in a sense, an interest. It may not be a very big one or a very live one, but an interest in the subject matter of this case. And Lady Hale has a particular point to raise which she would like to draw to your attention.
Well, I am married to a person who is, at the moment, a fee-paid chairman of residential property tribunals. He is also about to retire. So he is undoubtedly in the same class as recorders, although in fact in that particular tribunal they are, I am told, taxed under Schedule D, and if they are registered for VAT as he is, they charge VAT on their daily fees. Nevertheless, I thought it right to draw to your attention the fact that my spouse is in the class of persons who are like immigration judges to whom this applies.
My lord, my lady, I'm laughing not because the point is not serious, because it clearly is serious and important. I'm laughing only because it was the first thing that I was going to raise with your lordship and with my lady. And I was not aware, or at least had not thought through the position of your husband, Lady Hale. I should have done. I had taken the liberty of looking each of you up in who's who to try and calculate whether you would have had 20 years of judicial service by the time any of you might come to retire. And as far as I could see, you either would, well, you either already had, or were very likely to have done so.
I think your arithmetic was perhaps a little stretch. I think most of us, in fact all of us, are on 15 years rather than 20.
Well, I beg your pardon.
But there we are.
But you're quite right. But I raised the point with my learned friend precisely as to whether there might be any objection on the basis that any of you might just possibly have a marginal interest in the case. And we did not raise the position of Tarrant, obviously, but he was very gracious to say that he took no point on it. So I think I should sit down for a moment and allow him to respond precisely to the point that Lady Hale has made.
Yes, my lords and my lady, we knew it was inevitable that each member of the court would, at least in theory, have a financial interest in this case, as indeed as my learned friend and Ms. Moore and myself as part-time judges. We don't take any point on the appearance of bias, and I don't need to take instructions in relation to my lady's husband. The position, I have no doubt whatsoever, remains the same, that we are very happy and content with the composition of the court as it is.
Thank you very much indeed. Good. Well, we don't need to adjourn, and we can proceed with the... Thank you very much indeed.
And indeed, as Mr. Cameron so clearly stated, both he and I and one of his juniors are reporters as well, so we do have an interest in the case. My lord, my lady, you preempted perhaps my short introduction, and it won't take very long. I'm here with Ms. Krasnow on behalf of Mr. O'Brien, to my right, and to my left, Mr. Kavanagh and Ms. Sarah Moore, and sitting in the row behind, Ms. Holly Stout on behalf of the Ministry of Justice. Before we go any further, with a formal introduction to the appeal, can I say that there are three very short points which need to be either added to or corrected before I get into the detail of this. There has been an error in the index to the Lucy, and we would like to offer you a second page, which the usher is saying is either on the bench or it has been
Yes, I think we have that. Yes, thank you.
Yes. Secondly, there is an error in page 266, paragraph 266 of our case, which, although this is simply a gremlin, it was spotted before the case was filed, but for some reason or other not properly corrected. And if your lordships and my lady would look, this is in that section of the case which details the history of the introduction of the regulations. Our case is tab 3, obviously, in the first line volume. And it's a small point about the way in which certain documents came to be disclosed, which is not correctly put in paragraph 266. I very much doubt you will need to refer to it later, but it's important to have it accurately stated.
The sheet that I've been given seems to have only a few lines, the first 3 lines of 266, which matches what I have on page 73. We don't have any, at least my copy doesn't have any on the reverse. So
Mine does.
perhaps I'm just being...
Well, then another glitch has happened because it should have been done on a double-sided piece of paper.
Some of us have it and some of us don't. So don't
But
let's take
can I
up...
just simply say for the moment,
Yes.
and we'll pick this up at lunch, if you could go in the Combine volume and cross out the sentence, this ruling led to further documents being disclosed, because it's that which is inaccurate. It's on page 74.
Which
the
paragraph?
documents had actually been disclosed earlier to
Which paragraph is that in?
Paragraph 266 on page 74 in our case.
I don't see the words that you've just read out, actually.
266 over the page.
Over the page, and then
This ruling led to
this
further
ruling led to
documents
further
being
documents
displayed.
being disclosed. It is that sentence which is incorrect.
Well, mine hasn't got that.
No, in the Combine volume, my lord, rather than the legal. It's
I had previously a separate one,
So have
and
I.
the separate one seems to have already encompassed the change.
has made the change.
I
Yes.
see. Well, that's right.
Right. That's...
Well, then, for some reason, it got back into the Combine volume in the wrong form. I don't know why, but it did. But if you've got the amended version there, then we don't need to worry about that.
Now, I've been using, as Lord Clerk has, the separate version.
Right.
Is that going to cause a problem?
No, not at all.
Good.
It's just the Combine volume is wrong, and you need to know that.
Right, thank you.
The final short point, right at the introduction, is that we thought that it might give assistance to the court to have the Courts Act 1971, Section 21, as it relates to the appointment of recorders at every stage from passage of the Act through to today's date. And so there should be a little clip which gives the complete iteration of the Courts Act 1971.
Thanks.
Now, you may want to have that simply on the bench. I shall certainly refer to it shortly. But if you want to tuck it in anywhere, it would naturally go in volume 5 at tab 91.
Yes.
My lords and my lady, really only want to say a very few words in opening because, as you will have seen already, our case sets out pretty fully the context within which this argument is to be developed. And both, I think, Mr. Pavner and myself consider that we've got quite a lot of territory to cover in quite a short period of time because the case is listed for today and tomorrow. Please do ask me if you think that I've taken it too shortly. But as your lordships and my lady will see, this case involves considering the part-time workers regulations and the part-time workers directive. Both construing the directive and understanding the obligations that flow from that on the United Kingdom, and also construing the regulations and seeing whether they are conformable to the directive itself. That's the interplay of the European and domestic legislation. The territory over which it plays is, of course, the legal relationship, such as it is, between recorders and the Ministry of Justice or the state at large. And as our case has shown, we intend to focus first in detail on the nature of that relationship before coming to the directive and to the regulations. But it may be helpful just to make sure that you have already identified where the regulations and the directive are, and to remind ourselves very shortly of the nature of the problem that lies in front of us. And for that purpose, if you could pick up the core volume 2 of 2, you will find, I hope, have already found, that the directive, the Part-Time Workers Directive, is at page 431. That's worthy of a tab, and the regulations follow shortly afterwards at 440. Taking it very quickly to see the issues, and without at this stage looking at any of the recitals to the directive or to the agreement which is part of the directive, you will see at 435 that the purpose overall of the directive is at clause 1a to provide for the removal of discrimination against part-time workers and to improve the quality of part-time work. The mechanism by which that is achieved is through clause 4, the principle of non-discrimination. In respect of employment conditions, part-time workers shall not be treated in a less favourable manner than comparable full-time workers, solely because they work part-time, unless different treatment is justified on objective grounds, and where appropriate, the principle of pro rata temporis shall apply. I don't need to read the rest of that clause at this stage, and then there are provisions for opportunities for part-time work and provisions on implementation. So the purpose is achieved by applying the principle of non-discrimination. The question that falls for decision in this court is whether judges, that is to say recorders in the instant case, are within the scope of the directive. And the scope clause is set out in clause 2. It is in two parts, and both parts are important. Clause 2.1 states, this agreement applies to part-time workers who have an employment contract or employment relationship as defined by the law, collective agreement or practice in force in each member state. 2. Member states, after consultation with the social partners in accordance with national law, collective agreements or practice, and or the social partners at the appropriate level in conformity with national industrial relations practice, may, for objective reasons, exclude wholly or partly from the terms of this agreement part-time workers who work on a casual basis. Such exclusions should be reviewed periodically to establish if the objective reasons for making them remain valid. Now, I've read both parts of that because I want to make an initial point of some importance. It is this. We shall have to grapple in some detail with the meaning of clause 2.1. But your lordships, my lady, will see immediately that clause 2.2 provides a mechanism from the derogation of the application of the directive through a particular control mechanism. In short, you can see in clause 2.2 that if a member state seeks to derogate from the application of the directive in relation to what one might call marginal, or in this case casual workers, it can only do so after it has gone through a consultation process.
Can I just go back? I mean, clause 2.1 is fairly precise in its terms and is looking at what the law defines, or collective agreement or practice. And I suppose if you fall outside 2.1, you don't get to 2.2.
That's entirely right. But because of the need to construe an agreement such as this, and indeed a directive as a whole, it's important to show that the marginal case is dealt with through the control mechanism. And it leads immediately to my first point, that the directive is intended to be construed on an inclusive basis. In short, where there is a marginal case, there is a control mechanism for taking it out of its application. I shall develop this point and show that that is in accord with the social policy within which this directive is made, which includes, as it were, the purpose set out in clause 1a. Now, it's a short point, but it's one that will need to be borne in mind as we develop this case, because it's an accepted fact that although there was some discussion in relation to these regulations about the possibility of using clause 2.2, it is not the case for the Ministry of Justice that clause 2.2 was ever used to create the exclusion which we shall have to look at in due course. i.e., recorders were not treated as a marginal case, casual workers, and excluded through the consultation mechanism. The respondents will have to establish their case that they are clearly outside clause 2.1. Secondly, in relation to clause 2.1, this will require some quite careful thinking. It seems at first reading to suggest that member states can, of their own accord, classify employment relationships and therefore in their regulations define them in or define them out.
Well, your point is it can't possibly mean that.
In one.
So it can't mean, as it were, ex post facto definition to take them out.
There are a number of different important points about this. Certainly it can't be done by ex post facto definition. Certainly. Secondly, that because this is within the scope of the social policy of the European Union, as we must now call it, and it is concerned with fundamental rights, again, as I shall demonstrate, it isn't permissible for the member state to pick and choose, as it were, a la carte, which definitions of employment contract or employment relationship apply it to those types of work which it wishes not to give rights to part-time workers, and then in its implementing regulations exclude them. There's a more fundamental purpose that lies behind clause 2.1.
And the proposition, as you've just framed it, is not peculiar to part-time judges. It would apply across the board.
Oh, absolutely. I mean, the point here is that we need to look at how it applies in the context of judges. It will come as no surprise to you that I shall seek to demonstrate that judges work for salaries or remuneration in a context which is well defined, which is in fact susceptible to analysis as being subject to legal relations, and if not contractual, is certainly close to being contractual, has been described on a number of occasions when analysed as being either in employment or close to employment. Indeed, that the state itself, when deciding whether to tax judges from the very outset, has treated them as employees.
You mean Schedule E?
Schedule E, but it's expressly explained it, indeed so, expressly explained it in the correspondence to Mr. O'Brien as him being treated as being in employment.
Which is one of the reasons why I drew to your attention the exceptional case of which I happen to have personal knowledge.
You've sent us helter-skelter back to analyse why that might be, but it's certainly not the case for Mr. O'Brien. Yet has chosen, as it were, to ignore all these matters and treat part-time judges, such as recorders, as not being employees, on the asserted basis that because they're office holders, they are not to be seen as being employees. Our response to that, in short form, is you can be an office holder and yet be an employee.
But employee is not the question, is it? The question is employment relationship.
Well, it is whether there's a contract of employment or an employment relation. And in our cases, we say we can achieve the high ground, we only need to achieve the low ground of employment relation, and we can certainly demonstrate that that applies here.
Well, it's relationship.
Relationship, I beg your pardon. Now, that is a very quick look at the directive, and I will need to make much more detailed submissions about it in due course by reference to the authorities. Can I ask you to turn forward, as it were, to contextualise the debate to the regulations, which are at page 440. I'm going to do this in a slightly back-to-front way, but by taking you straight away at 450 to Regulation 17. It's Regulation 17 which has been the barrier that's been pleaded to Mr. O'Brien's case from the outset. These regulations do not apply to any individual in his capacity as the holder of a judicial office if he's remunerated on a daily fee-paid basis. And certainly a recorder is remunerated on a daily fee-paid basis. There is no doubt about that. If we are right about our construction of the directive, it is accepted that the directive is directly applicable, and therefore either Regulation 17 would have to be read down, or alternatively, we could simply rely on the directive as having direct effect. That is dealt with in the fifth part of our case, but it now not being an issue that the law has moved on in the Court of Justice, that the directive has direct effect, I do not propose to take any great time in elaborating the law on direct effect, or indeed the law on construction of regulations which are enacted in order to give effect to directives. The FIFA line of authority, Kuchudovicii against Swedex, Marshall, and so on. If your lordships wish me to do that, I'd be grateful to know at some point so that I can time manage my allotted time suitably to deal with it.
Well, I think it's fairly familiar ground. Just to be quite clear, you said part 5 of your case. And you
Yes, it's part 5.
Could you just directly
consequences in the printing case.
Sorry?
Part 5, which is page 82. The consequences of the exclusion in PTI found out that the daily fee paid judicial officers being constituted.
Yes. Yes.
And we've set out there some fairly familiar case law, FIFA, and then we've shown at pages 84 and 85 that it's now accepted that the similar directive for fixed-term work as opposed to part-time work has direct effect. And then we've gone on and dealt with some domestic case law as well. But I do not understand it to be argued by Mr. Kavanagh now, following the judgment in impact, that the directive does not have potential direct effect.
But he says that paragraph 134 of his case.
He does indeed. But I say that now simply because I'm not going to spend time on that, given how time for time we shall be, and I don't think it needs elaborating. So that's Regulation 17. The question, therefore, is, can Regulation 17 be justified or established as a lawful enactment in the light of the directive? To go to the front end of the directive, one can see how the directive itself approaches the regulations, I beg your pardon, enact the directive. At 443, of course, in Article 5 of the Regulation 5, on Part 2, you will see the right not to have less favourable treatment that we've already seen in Clause 4 of the agreement. is largely replicated. It applies to a part-time worker who has the right not to be treated by his employer less favourably than the employer treats a comparable full-time worker. So the right applies to a worker, and a worker is defined on page 441. The differences between full-time workers and part-time workers and comparable full-time workers are dealt with in Regulation 2, and my Lord Hope and my Lady Hale will recall possibly that they heard me on this matter in Matthews and the Fire Authority case. I've done quite a lot of work since then, but you have had to look at those regulations previously. But at the top of the page, you'll see that a worker is defined as being an individual who's entered into or works under, or, except where a provision of these regulations otherwise requires, where the employment is ceased, worked under any contract of employment, and that's put in general terms, but we will see that it means there the most restrictive sense of a contract of employment being a contract of service, and you will see that
It's defined.
the opposite page.
Yes.
Or any other contract, express or implied, and if it's expressed, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not by virtue of the contract that of a client or customer of any profession or business undertaking carried on by the individual. In summary form, B, therefore, extends from the most restrictive idea of a contract of employment, rooted in the 19th century law of master and servant, to the relationship, to those relationships where there is personal service, but not carried out on a business basis. Now, of course, I paraphrase the words, but you can see that is the essentials of it, and we will see there's some case law on that too.
Could you just explain that last phrase, but not on a business?
Well, you can see whose status is not by virtue of the contract, that of a client or customer of any professional business undertaking.
Yes.
So an architect, for instance, might provide services, and the developer or a private individual would be a purchaser of the services of the architect. That would be a professional example. A business undertaking carried on by the individual will raise some marginal questions. For instance, if a company had a cleaner, the cleaner might hold themselves out as being in a business relationship, but if the truth of it was that the cleaner had no other clients, it might well be that they were held to fall within B. Essentially, it's drawing a distinction between those that are trading in some form or another and those that are integrated into the organisation under which the contract is made, or with which the organisation is made. And that,
But it's limited to a contract. It's got to be a contract.
in that definition,
In this definition.
it's unquestionably right, it has to be a contract. And the employment relation issue is only dealt with obliquely in the regulations. It's not dealt with front on. There's nothing that defines an employment relationship in the text that you find in the directive. The only place that you can find anything equivalent to that is in Regulation 12, and the regulations that follow after that under the heading Special Classes of Third Person. And that deals with Crown employment, the armed forces, household staff, the police service. And essentially, the Crown employment one we will need to look at shortly, but it's clearly historically designed to deal with civil servants and to avoid questions about whether civil servants are employees or not, because they may or may not have a contract. The Armed Forces, House of Lords staff, House of Commons staff, and the police service were all brought within the scope of the regulations. The detail of that you don't need, I think, at the stage to go through. So one can see that there is a large range of scope within the part-time workers' regulations. The only serious case, other than the Court of Appeal judgment, that's construed these regulations in the context of judges was a case called Christie, which you will need to look at. It's a judgment of Mr. Justice Elias, as he then was, in the Parliament Appeal Tribunal. And the approach that he took was to say that the directive essentially gave the member state a discretion as to how it would implement the directive. And as I shall show you in due course, he did not have the benefit of the up-to-date case law on the directive, which shows that there is essentially a discretion to include marginal cases, but no discretion to exclude those that are properly described as having contracts of employment or an employment relationship. He thought that it was open to the state to make some, as it were, marginal exclusions, and you could simply do it as a matter of discretion. We shall show that that approach was wrong. Those are the texts, the legal texts, within which this debate will have to be carried out in terms of the effect of the regulation, effect of the directive. What I want to do now is to put in context the nature of the problem for Mr. O'Brien, and also to look at the documents that defined his relationship with the Ministry of Justice and its predecessor departments. Firstly, it's common ground that there is literally no provision, which, statutory provision or otherwise, substatutory provision, which provides for pensions for recorders or for other fee-paid judicial office holders. Literally none. On the other hand, as your lordships will know, my lady will probably know, pensions are dealt with for circuit judges, Crown Court judges, and the higher judiciary. There are two enactments that deal with that, which we should perhaps open shortly to look at. They're both in Volume 5 of the authorities, at respectively tabs 97 and 100.
Why do my male colleagues definitely know and I only probably know?
I'm sorry, I'm sure
That was a slip of the tongue, wasn't it, Mr. Allen?
Slip of the tongue, yes.
I just thought I'd clarify that for the benefit of the other women in the room.
I don't know what, I was thinking another thought, I suspect, as I expressed myself inadequately. There are two pieces of legislation. The first was the Judicial Pensions Act of 1981, and Section 5, the court will see...
Which tab? I beg your
I
pardon.
beg your pardon, tab 97 in Bundle 5.
97, yeah.
I'm going to use the gender-neutral court, and then I shall get into trouble. Section 5. A circuit judge may, on the recommendation of the Lord Chancellor, be granted a pension. And then, if you will turn, please, to tab 100, to the Judicial Pensions and Retirement Act of 1993, which effectively replaced the Judicial Pensions Act. At Section 1, this part applies to any person who first holds qualified judicial office on or after the appointed day. And then you can see B, to any person who immediately before the appointed day was holding any qualifying judicial office, service in which was, in his case, subject to a judicial pension scheme, and so on. Critical words, and a qualifying judicial office, that's defined in subsection 6 on the opposite page. For the purposes of this Act, a person shall be regarded as holding or serving in qualified judicial office at any time when he holds on, keywords, a salaried basis. Any one or more of the offices specified in Schedule 1 to this Act, which includes, of course, Crown Court judges. but not recorders. And salary basis is then defined in the next following subsection, which I'd like you to note. I don't read it out to you. Over the page, section 2, the right to a pension follows from section 2. So, those are the rights that are given. They're given on the basis of being applied to salary judges. There's no doubt at all that at that time, the vast majority of salary judges, possibly the entirety of them, were full-time. There is some debate between the parties as to whether there were at that time any judges who'd been permitted to work less than full-time, perhaps on the basis of illness or something of that kind.
I appreciate it came a little bit later on, but you're saying, so far as you're aware, in 1993, they were all full-time.
It was certainly, there were negligible numbers of non-full-time salaried judges.
I suspect that there will have been some ad hoc exceptions made,
We believe that to be
but
the
not
case.
the same structured scheme that was developed in about 2003, 2004.
The need to enable some posts to be held on a part-time salary basis did not emerge until the 2000s, and in the light of increasing understanding of the needs of the diversity of work opportunities that were needed to enable all sorts of different people to be able to follow a judicial career. So that's the pensions background. Now, I've set out in the case, we've set out in the case, the background to the request to be able to have a pension. It may be helpful for your notes if I simply say that after very long service, Mr. O'Brien retired on the 31st of March 2005, and by the 16th of September 2005, after correspondence had been exchanged, he commenced his proceedings. There is a detailed history of the proceedings, which is in the annex to our case. And perhaps I can put this shortly to you. I hope the court has had an opportunity to read that. The background to it is that essentially a point in limine was taken by the respondents, effectively a strikeout application, on two bases. One, that his claim was out of time, and secondly, that his claim could not be brought under the part-time workers regulations because of Regulation 17. The Employment Tribunal decided his claim was out of time, but extended time as it had a discretion to do so. The respondent appealed to the Employment Appeal Tribunal in front of Mr. Justice Langstaff, who allowed the appeal and held that the claim was out of time. Permission to appeal to the Court of Appeal was sought and refused by Mr. Justice Langstaff, and an application for permission to appeal was therefore made to the Court of Appeal. Lord Justice Maurice Kay initially refused permission to appeal, but said if the respondents did not object, he would grant permission to appeal so that the second point could be argued in the Court of Appeal, that is to say, Regulation 17. They kindly did not object, and therefore the point was raised in the Court of Appeal. But you will recognise immediately in the Court of Appeal there were 2 points, the time point and also the construction point, or the legal point in relation to Regulation 17.
And the time point has disappeared.
Time Point has now disappeared, and this House, this court, the House of Lords Judicial Committee granted permission to appeal before the formation or before the start of the Supreme Court. So that's how the matter comes in. All that's set out in detail in the annex. Now, what I propose to do next is to take you through the terms of appointment that are apt in relation to appropriate that apply in relation to Mr. O'Brien. First of all, if you could pick up the little folder which contains section 21 of the Courts Act 1971, the context within which recorders came to be appointed is there set out. 1971 was the date in which recorders, as we now know them, were created. Prior to this, there were, of course, office holders such as the Recorder of Manchester or Liverpool and so on, which are of quite different kind altogether. The remaining recorder, I think there are some others, but certainly the Recorder of London continues on that basis, but that's not what we're talking about. Section 21. Her Majesty may from time to time appoint qualified persons to be known as recorders to act as part-time judges of the Crown Court. So it says in terms that they are to be part-time Crown Court judges, to carry out such other judicial functions as may be conferred on them under this or any other enactment. 2 deals with the process. The appointment shall be of a recommended person who is qualified. The recommendation continues throughout the iteration of the section. The qualification changes slightly, but it doesn't matter. Essentially, what it comes down to is a number of years' practice as a barrister or a solicitor. The appointment of a person as a recorder shall specify the term for which he is appointed, and then also must specify the frequency and duration of the occasions during that term on which he will be required to be available to undertake the duties of a recorder. In short, sitting obligations. So a period of employment or of appointment, and the sitting obligations must be specified. And then, subject to subsection 5 below, the Lord Chancellor may, with the agreement of the recorder concerned, from time to time extend for such period as he thinks appropriate. And note please there the word agreement, so it contemplates at the outset that there will be a series of potential agreements between the Lord Chancellor as to the term. It's interesting to note that although the appointment comes from the Crown, the extension is the gift of the Lord Chancellor. Over the page.
Just before you read that, of course, it's common sense that the appointment is not forced on individuals. No doubt they seek it, and therefore there is a process of application and acceptance. It's structured in that way, isn't it?
Indeed so. And we shall see that in the correspondence.
Is that right? Was it originally an application?
In fact, this is all dealt with in the witness statement that was in front of the Employment Tribunal. And I shall summarise it, I hope accurately, that at the time the then Peter Rawlinson was leader of the Western Circuit, the late Lord Rawlinson of Ewell. And he encouraged members of the Western Circuit to apply to become recorders. So Mr. O'Brien, at a very young age, actually, in his middle 30s, was encouraged to apply to become a recorder by the then leader of the circuit. And of course, my Lord Clerk asks, did he apply? Yes, of course he had to apply, but it was, in a sense, it was typical, I think, of the process that was then followed through encouragement, through seniors within the profession.
Well, they had something called an assistant recorder then that they invented completely extra statutorily.
And indeed, that's how I started my career as a recorder. But Mr. O'Brien was never an assistant recorder. He hit the ground running, as it were, and was a recorder from the outset. The whole of the statement that sets out the facts in relation to that is in Appendix Part 2 at page 35. And if I could just ask my Lord, the Court to look at that for a second. Lost it. No, it's the appendix, sorry.
Yes, it's not very easy to find the numbering in this
It's the thin blue-bound volume.
Yes. Is it his witness statement we're looking for?
That's it. His witness statement starts there, and he explains how he came to be appointed. Throughout that. And you can see the point I was raising in paragraph 9. In May 1976, I with others. This is on page 37. He was asked by Sir Peter Rawlinson, then leader of the Western Circuit, to consider applying, and he applied, and the process was then carried out in paragraph 10 and onwards. I doubt any of this is controversial, and it's certainly correct that this statement was read to the employment tribunal, but I cannot say there are any express findings in relation to this, but I'm sure that the Court can take this, as it were, at face value in relation to it.
The application process has undergone some kind of change over time, hasn't it? I mean, presumably now it's much more formal.
Well, there are advertisements now,
and,
if you wish to
Competition, there's competition.
Indeed so,
Yes.
and it's done now through the Judicial Appointments
Yes,
Commission,
yes.
which have the process of selecting those that they consider should be recommended for appointment. And then the Lord Chancellor still, as I understand it, makes the recommendation to the Crown. So the appointment comes, as it were, through the Lord Chancellor, through the Ministry of Justice. We can certainly bring the Court up to date with absolutely the latest word on that, perhaps with a download from the Judicial Appointments Commission website, which might help you.
But does it make any difference?
None at all, as far as I can see. But it just...
No, I think I was just going back to Lord Clark's point that originally it was pretty informal, wasn't it? I mean, just reading what he says, I imagine there was no particular style of doing this. He had to nominate, as he says, suitable referees, but it was fairly straightforward.
Well, I should give evidence to the Court, but I failed on my first application as an assistant recorder. And immediately after I failed, the then Lord Chancellor's Department said that they would have equal opportunities assessment, and my application was then reconsidered, and I was appointed, having been encouraged in the first place to apply. And so there has been a process of professionalisation of the appointments process, of that there is no doubt at all, leading now to the Judicial Appointments Commission, where there is a very formal process of interviewing for recorders, just as there is for High Court judges and indeed many other judicial posts. But if I can just finish with section 21 as it was, and then take you back to the case. I was on subsection 5, and I had invited you to note that there was power to agree an extension. And then in 5, neither the initial term for which a recorder is appointed, nor any extension of that term under sub 4, shall be such as to continue his appointment as a recorder after the end of the completed year of service in which he attains the age of 72. Now, I don't put undue weight on that, but it is significant that it is seen as a relationship of service in the Act from the outset. And then 6, the Lord Chancellor may, if he thinks fit, terminate the appointment. And the two core reasons are incapacity or misbehaviour. Those are elaborated in later iterations. There should be paid to recorders out of money provided by Parliament such remuneration allowances as the Lord Chancellor may, with the approval of the Minister for the Civil Service, determine. And then you will see that the Act was amended under the Courts and Legal Services Act of 1990, in the next page, the provision in relation to service remains in subparagraph 5, paragraph 21. There's a further elaboration between 1995 and 2006 as a result of the Judicial Pensions and Retirements Act. And you can see that and indeed the Courts and Legal Services Act, you can see there's a difference in the qualifying provisions in sub 2 and a change in relation to the retirement age in sub 5.
Am I right in thinking the word service has disappeared?
It does
there, but the word agreement is still to be found in 4.
But it's, in our submission, it's not because it's been excluded because they want to change the nature of the relationship. It is simply that in our submission, in sub 5, the new sub 5 substitutes, instead of simply a blunt age cut-off of 72, it's the age of 70, continuous employment, and the subsection is subject to. And then the next iteration is over the page, and there are various further changes, but again, principally dealing with the question of misbehaviour and so on. This is the effect of the Human Rights Act. And the final version from 2008 is the last document. I'm not going to take further time with it.
Thank you.
So that, obviously the last page here is not relevant. In fact, the last 2 pages are not relevant to Mr. O'Brien, since his service was completed in 2005, but it does cover, bring us up to date.
I suppose the footnote has the benefit of telling us when the Judicial Pensions and Retirement Act 1993 came into force, which was the 31st of March 1995.
Right.
Which gives you the answer to
Yes, it does,
the
yes.
point you were making earlier.
Yes. And the original Act continues in force for those appointed before. In our case, pages 14 and 15, we've set out the first and last versions of section 21, and I say no more about those, but I invite you to turn to paragraph 58. And we make our first point here, that just simply looking at section 21, there are strong similarities between the section and what one might call work or employment. A judge is in service, at least was until that amendment to which Lord Hope referred. Professional qualifications are required, duties must be undertaken, the specification of the frequency and duration of those duties, term for the duration of the service. The payment is defined as remuneration, which is the language essentially of employment, and there's provision for early termination on incapacity and misbehaviour, which are classic indicia of an employment relationship. The word misbehaviour itself tends to suggest a relationship of employment. And we then point out the similarities. Of course, it's not close and complete identity, but similarities between that and ordinary employment. Both the initial and later versions, as we say, speak of service, and a contract of service for unfair dismissal reasons and associated rights is a necessary precondition under the Employment Rights Act of 1996. So if your lordships would just turn to volume 5 for a moment, at tab 102, which will be the big 2. I'm afraid it's rather confusing, they haven't put the 100 in fact. And we have the Employment Rights Act there at page 28, just at the end. The Employment Rights Act defines employees in section 230. In this Act, contract of employment means a contract of service, that's sub 2. Doesn't have the extended version, which we've seen in the regulations, but we'll pick that up later. And then in sub 4 and 5, in this Act, employment in relation to employee means employment under a contract of employment. Now, this Act is interesting for another reason, because the key indicia of a contract of employment have to be set out in a written statement that is given to employees. And you can see that it covers very similar territory to that which you have to get, essentially, through the Section 21 process. So if you'll go back to the beginning of this tab, right to the index, you'll see there's a right to statements of employment particulars, statement of initial employment particulars, and of summaries, summary additions. And if you'll then turn to section 1, where an employee begins employment with an employer, this employer shall give to the employee a written statement of particulars of employment. And if you'll cast your eye down, it's also in our case on page 19.
But does this Act apply to judges?
This Act doesn't apply to judges. This applies to those that are defined as having a contract of employment as specifically defined within the Act.
Sure.
It's not been applied to judges.
And
the point I simply made is that there's a close correlation between it.
Yes, the reason why you say it doesn't apply is because of what we see defined in section 230, is that right?
That is the way that it has been construed as not applying to judges.
So what's your submission about that?
Well, our submission is that it could be considered as applied, but I want to develop that submission after I've taken you to the case law that follows afterwards, if I may. But whether or not it applies doesn't matter if it's simply a question of an employment relation as opposed to a contract of employment. Nor does it matter if you consider that the better construction is that there isn't a contract of service, but there's a contract to personally undertake work, the extended version of the definition of a contract, which we find in the regulations. So this is specifically designed to go to those that only have contracts of service. It's a necessary condition.
Well, of course, when they use the term worker, they include the broader type.
Absolutely. And
I mean, 3B is very similar. They're not identical, but it...
Okay. So the point at this stage is simply that you can see that Section 21 essentially covers very similar territory that you would find in relation to an employee who is uncontroversially an employee and protected from unfair dismissal within the canon of the employment law now set out in the Employment Rights Act of 1996.
Forgive me for being slow, but I just want to be quite sure how the word worker in section 230, subsection 3, is built into what one finds at the beginning of the Act. A worker is distinct from an employee.
Yes, and the reason for that is that there are some rights within the Employment Rights Act which go to the wider definition of a worker.
Yes, right.
Mr. Allen, your microphone's off. I think we can all hear you perfectly well. I don't know whether it's affecting anyone at the back. I think there's a button just...
I've got it.
Found it. Right.
I'm very sorry. I'm very conscious. When I only appeared once before in this court, which was the Jewish Free School case, and we were all putting the microphone on by catching ourselves, and I'm afraid I'd forgotten to...
I think it's been altered a bit.
It has now been altered, and I apologise.
And the problem isn't as bad in this court as it is upstairs in the
Right.
big court.
Well, as long as you can hear me, that's...
I think we can all hear you perfectly well. I'm not sure about those behind you. Yes.
Right. Thank you, my Lord Walker. That's helpful. So I've shown you the relationship with the Employment Relations Act shortly. I now want to show you the way in which he was appointed, and also to show you more widely the way in which there is a close interrelationship between service as a judge and employment. But if I can take you through the way in which he was appointed, that's in the appendix.
Going back to part 2.
Appendix part 2.
Yeah.
The first page, page 1, is a letter from the Lord Chancellor's office. And this really picks up the point my Lord Clerk was making. The Lord Chancellor has asked me to let you know that he would be pleased to recommend you for an appointment as a recorder with a view to your sitting on the Western Circuit. Before doing so, he'd like you to confirm that you'd be ready to accept appointment on the terms given in the enclosed memorandum. And we say the language of acceptance on terms is significant, perfectly clear that confirmation of agreement to those terms was a precondition for the recommendation from the Lord Chancellor. The terms themselves are set out over the page, at 1A onwards. They're headed Terms and Conditions of Service of Recorders. It's a memo. The whole of this, of course, is relevant, but I'll just pick out some key passages. The conditions include, as you can see in paragraph 1, this memorandum contains information about the conditions of appointment, which may be found useful by those interested in applying. So it's addressed to applicants in the first place. Appointment is dealt with in 2 and 3, the process. But the obligations include sentencing conferences, so that's the training provision in 4. Minimum sitting in 5. Direction as to sitting, places of sitting are in 7. You can sit on or off circuit. The centres at which will be settled with him, so there'll be individual agreement about that. There are limitations on practice in 9 and 10, and indeed clashes of commitment dealt with in 11. And then 12 deals with fees. And this is important because what it shows is, in the language of employment, that there is an obligation to pay provided that the recorder is willing to work the minimum period, even if that work cannot be offered. So we see a recorder will receive a fee of £60 for each day in which he sits. No annual retainer will be payable, but a recorder who holds himself available to sit for not less than 20 days each year will be entitled to be paid accordingly, whether or not he is in fact called upon to sit for that period. And as I shall show you in a moment, this is typical of an employment relationship, that there's an obligation to work and a mutual obligation to pay. So provided you meet the obligation to work, the obligation to pay arises. Then income tax and national insurance are dealt with in 4 and robes. Over the page at 2, there is discussion about minimum periods of work, and congratulations on the appointment from, I think it must have been then, the Mr. Justice Dunn. Is that right? Yeah. You can see in the 6th paragraph that Mr. O'Brien was encouraged to sit longer than the minimum. Next pages 4 and 5 are the letters of appointment and the royal warrant. And then at 6, on the 27th of September 1978, this letter, sent from the Circuit Administrator, Schedule 6, paragraph 13 of the Finance Act, which was brought into operation 1st of January 1978, removes the exemption from VAT previously enjoyed by holders of a public office. After consultation with the VAT Administration Directorate, the Customs and Excise has conceded that recorders are excluded from the new regulations on the basis that full-time judges' appointments are in the nature of employment, and that their part-time colleagues perform the same functions and have the same powers, and that it would be invidious in practice to distinguish between them for VAT purposes, notwithstanding that the part-time employments carry no pension and have a different basis of remuneration. So the fact of being fee-paid and the fact of not being pensionable in pensionable employment does not stop the VAT Office equiparating the service as a recorder with that of service as a circuit Crown Court judge, which is treated as being employment. And then at 7, the first offer of an extension is sent through the Lord Chancellor's office in 1981. And again, the language of offer and acceptance is patent. Under Section 21, the Lord Chancellor has power to extend the term of your present appointment. Lord Helsham asks me to say he is grateful to you for the service which you've already given, and that if you are willing, he will be glad to extend your appointment, subject to the current conditions of service, a copy of which I enclose. Then the normal approach to that in the next paragraph, and in the following paragraph, the Lord Chancellor has asked me particularly to draw to the attention of all recorders the obligation in paragraph 5 of the conditions of service to sit for not less than 20 days. And the letter of acceptance is over the page at 8. Thank you for your letter. I'm happy to confirm I'd like my appointment as a recorder to be extended on the terms and for the period set out in your letter. So we submit that it shows quite clearly acceptance of the offer. Thank you also for sending me the current conditions of service, and there's a discussion about that. And that largely is repeated in 5 yearly stints, I think, 3 yearly and then 5 yearly, through to the conclusion of his service as a recorder. I don't take you through all of that, but the rest of this volume will show you how it worked through. And then finally, on the conclusion of his service at page 28, Mr. O'Brien was sent the P60, as indeed he would have been sent a P60 every financial year prior to that. But it's interesting to look at it. Do not destroy P60 end of year certificate, tax year to the 5th of April, employee's name, surname, O'Brien.
So sorry, what page are you on?
Page 28.
Thank you.
I'm afraid it has to be turned through 90 degrees. And it's a standard P60, end of year certificate, employee's surname, employee's works payroll, certificate by the employer, the paying office. It's all the language of employer and employee. Of course, it may well be said that having taken an internal decision to treat recorders as employees, they didn't bother to print a different kind of P60. But it does emphasise that he was taxed and treated as an employee throughout that period. And then the letter seeking the payment of the pension is at 29, and at 30, the refusal. Just pick up 30, 5th of July 2005, and at the end of the first fat paragraph, domestic law does not regard judicial office holders, whether full-time or part-time, or more accurately fee-paid, as having an employment contract or employment relationship. Accordingly, fee-paid judicial office holders fall outside the ambit of the directive. And that is how the litigation started, essentially.
Well, and then they take the regulation 17 point as a separate point.
They do, yeah. I'm sorry, I should have read to the end of the letter. For your notes, this may not be important, but the current terms and conditions are at 58 through to 58 onwards. And you might find it helpful to see paragraph 41 of the current terms and conditions. That's on page 64. Fees. The appointment is non-salaried and non-pensionable. Recorders will receive a fee for each day sat. The current fee is £575 per day. These fees are revised from time to time in accordance with the recommendation of the SSRB, and the fees are calculated by dividing the salary for the equivalent full-time office by 220. And it's an agreed fact between the parties. It's set out in the Statement of Facts and Issues that that has been the basis on which Mr. O'Brien has been paid throughout his service as recorder, i.e. the fees that he got were 1/220th per day of what a Crown Court judge would have received. But it's interesting to note one of the consequences of that in that calculation and the use of the 220 in the next sentence. The effect of this divisor is that a pro rata allowance for annual leave and public and privilege holidays is built into the daily fee. There's also a daily payment equivalent for half rate for going to Judicial Studies Board and various other points made in the rest of that paragraph.
Are part-time judges, not fee-paid judges, are they paid on the same basis? They're pensionable.
They are pensionable, so
are they paid on the same basis?
If they are appointed to sit 4 days a week, then they will get 80% of the full judicial salary.
So that is in effect the same basis.
Yes,
the same basis.
It is. So, but that paragraph 41 puts in absolutely clearly the direct relationship between the payment for each day served by a recorder to the payment on the salaried basis of the full-time Crown Court judge, and shows the allowance that is made. I should perhaps, as a footnote to the argument, simply say this, that there are issues about whether under European law, rolled up holiday pay of this kind is in fact permissible under the Working Time Directive, but that's not an issue that you will have to consider. I just simply say it's a footnote. If we go back to the case, then, it's also true to say that recorders are entitled to statutory sick pay, maternity pay, paternity pay, and adoption leave. And those are all set out in our case at paragraph 64 and can be found also at page 66 in the appendix in paragraph 52. And it needs no elaboration that those are rights which accrue to employees rather than to non-employees. So they are treated in that sense as being employees.
Page number again in the case is...
Page 66 in the appendix part 2, paragraph 52,
Yeah.
and in our case at paragraph 64 on page 20.
Thank you.
In the paragraph 20 of our case, under the heading The Tax Treatment of Recorders, paragraph 65, we set out that it is in fact necessary to treat recorders as employees in order to bring them within the exclusions on the obligation to pay VAT. That's in paragraph 65 onwards. And through to paragraph 74. I hope the court will permit me to take this one very shortly because we've set out our case fully there and I need to move on without getting too bogged down in the detail of the VAT directives. But you can see in paragraph 69, Article 4 of the 6th Directive provides taxable person shall mean any person who independently carries out in any place any economic activity specified in paragraph 2. And then in sub 4, the use of the word independently in paragraph 1 shall exclude employed and other persons from the tax insofar as they're bound to an employer by a contract of employment or by any other legal ties creating the relationship of employer and employee as regards working conditions, remuneration, and the employer's liability. So it's only through sub 4 of Article 4 of the 6th Directive that recorders can be treated as not providing VATable services to the state. If I can give you some marginal notes, to paragraph 69, the directive itself is in bundle 6 at tab 115. And Eleanor Sharpston's, Advocate General Eleanor Sharpston's opinion in Van der Steen is in the loose leaf section at tab J. And this point is elaborated in the next paragraphs, 71 through to 74. So the perverse result is that the state has to rely on Article 1 sub 4 of the 6th Directive, 4 of the 6th Directive, to exclude recorders from the VAT regime, i.e. basing it on the fact that they have a contract of employment. Yet, when it comes to the obligation not to treat them differently on grounds of their part-time status in relation to pensions, they deny that they have a contract of employment that falls essentially within the same kind of description. For your marginal note in 73, that's in the loose leaf at tab C. Now, I don't open that case up, but because I must, I'm afraid, move on now to look at some of the domestic law as to whether judges have a contractual relationship. Now, there are a number of interrelated issues around this question. First of all, whether judges have a contract, i.e. whether any agreement in relation to the service as a judge is, in fact, an agreement which involves an intention to create legal relations. That's one of the issues that the case law shows up.
So we're not talking about judges generally.
Exactly. This is under the heading as to whether judges have a contractual relationship in paragraph 75.
Yeah.
But I want to just flag up the issues that we need to explore. Intention to create legal relations, and whether it's properly classified as employment in the narrow or broader sense, i.e. a contract of service or a contract to personally perform work or labour. The overarching submission that we make is that it's quite inadequate to say that judges hold an office and to stop there. That is simply not sufficient. And our development of it is, we say that the documents that we've shown you, and indeed the statutory framework that we've shown you, anticipates that there will be agreement between the judge and the government, or the state in the largest sense, through the agency of the Lord Chancellor.
Just in passing, I think it's right to say all of us receive P60s in the form that you've shown us with the word employment stamped all over it.
I'm grateful for that. I'm not surprised either. But we would say that that is entirely consistent with the submissions that we're going to develop in a moment.
Could I just ask you, in Article 4.4 of the 6th Directive, which head of paragraph 4 does the state rely upon?
There is a number of directions from the revenue itself which covers this, which we do have photocopied, but essentially it treats them as having a contract of employment without disaggregating the last 3 lines of sub 4 of Article 4. But those can be made available. You know the usual directions that are set out from the Inland Revenue. Have we got them here? It may be helpful to hand them up since my Lord Clerk's asked the question. Give me one just marked up.
Do you mind making the point that we rely on 4.5, which isn't in your thing?
Which is your tab in your note?
It's paragraph 33 of our case.
Before the court reads this, could I ask you also, because I've been asked to do this by Mr. Kavanagh and I'm very willing to do it, in his case, he says that the 5th subclause of Article 4 is in place, is relevant. That's dealt with at page 15 of his case, and it might be helpful just to read that as well. Our submission is it's simply not in point, and you'll see that when you read it. Page 15 in paragraph 33, clause 5 says, states, regional and local government authorities and other bodies governed by public law shall not be considered taxable persons in respect of the activities or transactions in which they engage as public authorities, even where they collect dues, fees, contributions or payments in connection with those activities or transactions. In our submission, that is directed principally at the work of bodies like local government or health authorities or such like, not individual persons. But the treatment, this is the latest statement from the Revenue in relation to judicial office holders that we've just handed up. At 6.7, office holders' special cases are, second bullet point, judicial appointments. And then over the page, 6.7.2, judicial appointments. Full-time salaried judicial appointments, though technically public offices, are not caught by Section 94(4) of the Tax Act, since the services are regarded as supplied in the course of employment. Part-time judicial appointees who carry out the same functions and have the same powers as their full-time colleagues, not treated as making supplies in the course or furtherance of business, thus any allowances received by taxable persons are not subject to that. Examples of part-time judicial appointments include, and then you will see second bullet point, recorders.
Could you just explain what this document actually comes from? It's got page numbers.
This is the proper description of it is the VAT control notice issued by the Revenue, and it's VAT control note V1 to 6. And it's the up-to-date version of it.
Yes.
Bear with me for a minute. Yes. It's Mr. O'Brien, who found the note with his diligence, says that it is the instruction to VAT officers, the internal instruction from VAT officers as to how to deal with VAT questions.
It doesn't quite address the question which bit of the second part of Article 4.4.
That's what I said to you, it does not. It simply takes...
Fudges it.
It fudges it and takes it, as it were, on the run in that way. But that deals with that part of our case up to paragraph 74. And if I can now proceed to the next part of the case. I want, because it has been argued that there's essentially no contract, and the submissions in the respondent's case proceed on the basis that we have to persuade this court to see an implied contract between the parties in the documents that I've shown here. I want to make a first submission, which is terribly obvious, perhaps, to this court, but nevertheless is, I think, worth doing in very short form, by taking you to the law on the right approach to intention to create legal relations. I want to do that by reference to a case called Baird against Marks and Spencers and the judgment of Lord Justice Mance. Very short passage. It's in the loose leaf. At tab A. The background to this will probably be one that you will recollect, that for many years Marks and Spencers had a policy of purchasing British goods to sell in its shops, and it had a long-standing relationship with a textile manufacturer called Baird. And pressure of global competition led it to stop that relationship almost literally overnight. Baird were brought financially to their knees and sued Marks and Spencers, asserting that they had a contractual relationship which could not be terminated without due notice. The problem was that they could not in fact point to any specific agreement. That was the problem that they faced. And it's perhaps no surprise that the Vice-Chancellor and Lord Justices Judge and Mance did not accept that there was an implied contract. But the passage I want to take you to in the judgment of Lord Justice Mance is at page 757, at paragraphs 59 and following. The Vice-Chancellor has set out paragraphs 12, 1 and 2 of the judgment below, in which Mr. Justice Morrison summarised the relevant legal principles as he saw them. For a contract to come into existence, there must be both A, an agreement on essentials with sufficient certainty to be enforceable, and B, an intention to create legal relations. Both requirements are normally judged objectively. Absence of the former, that is to say agreement on essentials, may involve or be explained by the latter, that is to say presence or otherwise of an intention to create legal relations, but this is not always so. A sufficiently certain agreement may be reached, but there may be either expressly, by express agreement, or impliedly, e.g. in some family situations, no intention to create legal relations. And then this passage, an intention to create legal relations is normally presumed in the case of an express or apparent agreement satisfying the first requirement. And our short submission to you is that the documents that have been exchanged between the parties, talking about terms and conditions, using the language of offer and acceptance and agreement, show that there clearly was an agreement of some sort on the essentials with sufficient certainty to be enforceable. It follows from that, as Lord Justice Mance put it, that normally it is to be presumed that where there is certainty of terms and a clear intention that they should be enforced, that you would presume an intention to create legal relations. So our short point is that the documents that we've shown you here go the distance of establishing an intention to create legal relations.
Is there then a right to payment, assuming that the judicial officer, the part-time judicial officer, does the number of days and so on, and the formula is set out in the papers?
That's what
So
it comes
that's
down
the
to.
best test of whether it's enforceable or not,
Yes,
I would have thought.
exactly so. And we say therefore, that any argument that says that simply because they're judicial office holders, that there's no intention to create legal relations in this context, founders on basic principles of contractual law as set out in law.
Does it follow that if a recorder is not given a minimum of 20 days' work a year and he wants it, he's entitled to it, that he can bring a claim suing for damages for breach of contract?
Exactly so.
And who does he sue?
Well, he would sue under the Crown Proceedings Act, or alternatively under the language of the agreement in the correspondence, the Lord Chancellor's Department. It would come to the same end. That's what he would normally do. And we will show there's nothing inconsistent with the common laws established before that is the right way to proceed, to sue on the agreement in that way. And there could be many different issues that need to be resolved. I mean, it could be that there's a debate about whether the offer was actually made, for instance, that sort of thing, or the right amount of money was paid. All that, we submit, would be resolved on a contract action in that way.
Well, you can have two different sorts of contract, can't you? You can have a contract to pay for such work as is done, and you can have a contract to pay for a minimum amount of work, whether or not it's done, provided the person is prepared to do it, which is how you construe the fee commitment in the first terms and conditions.
So we certainly say that on, as it were, entirely orthodox principles, that where you've got certainty of terms, it would normally be presumed that there was an intention to create legal relations. The alternative is very straightforward, because if this doesn't lead to a contract, the question that my Lord Sir John Dyson asks is, how does the recorder enforce it if nothing is paid to him when he's offered to do that work and said, I'll go anywhere in the country and carry out the office of a recorder, but it's not been offered? Ultimately, it would have to be dealt with as a matter of status in a judicial review application. There's no other alternative to fill the space.
The last sentence of paragraph 61 is quite interesting. It's Mr. Justice Morrison's way of envisaging, second last sentence, I think it is, envisaging a situation where actually there wouldn't be a necessity to imply a contract and there isn't actually an intention to enter into legal relations at all. And it's envisaging that somebody's prepared to go along and act as a recorder without any certainty he'll ever be paid for it at all.
Yes.
It doesn't seem right.
And give up professional obligations, to agree that he would not act in embarrassing situations and so on that are in the terms and conditions. It simply, in our submission, once one carefully applies essentially what is the first chapter of Chitty to the relationship, it resolves.
Is it an implied term of the contract that the recorder will exercise his judicial functions with all proper care?
I think I would put it in a slightly different way.
Because if there's a contract,
yes,
it's surely necessary to have such a term to make it work. So maybe it isn't a contract.
Well, I don't think that's difficult at all. Suppose, for instance, that one looks at it as to precisely what the contract is for. It is to do judging, in short. So
However incompetently.
Well, it's certainly to do it judicially and to be trained, and it's we would submit that there must become a point at which it's not mere incompetence, because there is obviously an obligation to act competently, because that's a ground for termination of the relationship within the provisions of section 21. It's a precise term. How that part of it would be enforced, it would depend, of course, on the determination. So, in the example that your Lordship gave, if a judge acted incompetently, it's likely to be remedied on appeal at some point or another, and the fact of the incompetence would be established through the appeal process. Once it's established through the appeal process, it might provide the ground for termination of the relationship that is set out in section 21 for incompetence. But that's how it would in practice work out. If your
There's
lordship's-
also a whole code of judicial conduct which applies to part-timers as
Yes.
well, isn't there?
Yes.
With gradation of sanctions.
All of that is set
Falling
out.
short, obviously, of removal, because
Yes.
that's very much
I mean,
the last
there
resort.
can be further training, there can be re-inducting of the recorder, and so on. So there is a process of management of performance which takes place. And my lord has sat in the Court of Appeal and had to look at what sometimes would be incompetent judging. I suspect all members of the court have had to do that from time to time. But I don't have any difficulty with this submission simply because there is a process of appeal which controls what judges do. Whether you get a different kind of remedy, whether, for instance, the state could sue for incompetent judging, I don't think that is contemplated by it, because what is contemplated by the relationship between the state and the judge is that the judge will act judicially as determined through the appeal process. But at some point, when the disciplining of the recorder in carrying out judicial functions has failed, then the Lord Chancellor's Department can dismiss or decide not to renew the appointment. That's the way the agreement goes.
Paragraphs 35 to 39 of the current terms and conditions of service deal with judicial conduct.
I'm grateful. It'd be worth looking at those for a second.
Well, they indicate there's a disciplinary process.
Yeah.
That there are standards and
Which, let me find it again. And that disciplinary process is very similar to the kind of disciplinary process that you would find for an employee. Essentially, you're put on notice of what the complaint is and have to account for it. Sorry,
yeah, there is a statutory basis for it as well.
Yeah. So we start, anyway, with establishing what the general principle for intention to create legal relations. Now, I want to take you through 3 cases fairly quickly before coming to Percy, which deal with the interrelationship between office holders and employment. The first of those is Miles and Wakefield, which is in Bundle 1 at tab 20. This is not directly about judges, but it's significant because Lord Templeman, and indeed Lord Oliver, equiparates the relationship between a judge and the state as to that of employment. What it concerned was the entitlement of a superintendent registrar, that's to say, registrar of births, deaths and marriages, to be paid in a context in which the registrar was taking industrial action by refusing to adjudicate on weddings on Saturdays, which must have caused untold annoyance to many people indeed. The claim, what happened was that Mr. Miles was refused payment for the Saturdays. And the argument was advanced that because he was the occupant of an office of registrar, the emoluments of the office were payable whatever he did. So if I take Lord Clark's point, however negligently he performed his duties, it was said that he was still entitled to be paid in full. A bold submission, which got nowhere at all in front of the then Mr. Justice Nichols, but succeeded 2-1 in the Court of Appeal. Lord Justices Parker and Fox agreed that that was the law. Lord Justice Evely did not, and got absolutely nowhere at all in the House of Lords. And essentially, what it came down to can be seen in the judgments of Lord Templeman and Lord Oliver. First of all, page 381, Lord Bridge agrees with Lord Templeman and Lord Oliver at G. I agree for the reasons they give that the salary payable to the plaintiff by the council was not an honorarium for the mere tenure of an office, but had the character of remuneration for work done. And then a little bit further down at H, you can see the question is put. I'll just read this passage. The more difficult question at the heart of the appeal is whether the council are entitled in any circumstances to deduct and withhold a proportion of the weekly salary. This depends in turn on whether in the like circumstances, if there had been a straightforward contract of employer, the employers would have the right to make such a deduction. So those are the two issues in the appeal. Lord Brandon at H agrees with Lord Templeman and Lord Oliver. And Lord Brightman on the next page also agrees. And then Lord Templeman's judgment starts at page 384, letter C. My Lord explains the background to the relationship. And it was an agreed fact, it wasn't in dispute, that this individual was not an employee. One can see that in the case, and then in the citation of Mr. Sedley's argument at G on page 386. Mr. Sedley, who appeared for the plaintiff, submitted, and the majority of the Court of Appeal accepted, that significance was to be attached that the plaintiff was not a servant under a contract of employment, but the holder of an office. In the olden days, satirised by Dickens and Thackeray, a gentleman appointed to an office, for example, in the Chancery Registry or in the Department for Circumlocution and Sealing Wax, carried out his ill-defined duties at his leisure and pleasure. Trollope explained that a special Act of Parliament was necessary to control the functions of the Warden of Hiram's Hospital. It's unusual for the holder of an office to take industrial action, and the consequences will depend on the rights and obligations conferred and imposed on the office holder by the terms of his appointment. But if an ambassador and the embassy porter were both on strike, then I would expect both to be liable to lose or both to be entitled to claim their apportioned remuneration attributable to the period of the strike. A judge and an usher on strike should arguably be treated in the same manner. The ambassador might be required to decode a declaration of war on Sunday, and a judge might devote his Christmas holidays to the elucidation of legal problems arising from industrial action, so that it would be necessary to divide their annual salaries by 365 to define a daily rate applicable to the period of strike. Whereas the weekly, daily or hourly wages of the porter and the usher provide a different basis for apportionment, but in principle it's difficult to see why there should be any differences in treatment. And then a little further on, in the judgment of Lord Oliver, which starts at page 395, we see this. Factual background from which this appeal rises has already been set out in the speech of Lord Templeman. Appeal raises essentially three questions. First, on the true construction of the relevant legislation and the local scheme, is the salary of a superintendent registrar of births, deaths and marriages an honorarium attached to mere tenure of the office, regardless of whether the office holder chooses to perform all or any of the duties, or is it in the nature of remuneration for work done, as was the view of Lord Justice Evely in his dissenting judgment? I need hardly add that was the conclusion that they reached at the end. Secondly, if the true nature of the plaintiff's salary is remuneration for work done, and thus to be equiparated to the salary or wages of an employee under a contract of employment, would the appellate counsel in the circumstances of this case have been entitled to withhold all or part of the salary in respect of a period in which the plaintiff decided to carry out the duties of his office, if he'd in fact been employed by the council to carry out those duties? And again, the answer to that question was yes. So we see quite clearly the House of Lords treating the remuneration of the office here, they obviously had a debate about the position of a judge's office, as being equivalent to remuneration for work done, as in a contract of employment, and that enabled them to hold in due course that if the office holder didn't work on the appointed days that he was expected to work on, just as in a contract of employment, didn't get paid for it. And we can see...
So the true nature of his claim was, what was his cause of action that succeeded, as it were?
What had happened is that in his claim, he claimed, this is Mr. Miles, had claimed for the honorarium in full for that part which had not been paid for the Saturday when he'd not turned up, or in fact I think he may even have turned up but hadn't done any wedding, carried out any weddings. And the point that was taken was that you don't get it because you didn't offer to work as you should have done, and just as in a contract of employment, we're entitled to say that if you're not willing to work, you can't plead that you're willing to work in full, you can't establish a contractual claim or any kind of a claim in court to get the payment.
But suppose he had done the work, but they hadn't paid, and he sued them for the money. That would be a cause of action, what, under the statute, or it wouldn't be under the contract, because it was a common ground there wasn't one.
It would have
so it must be under something else.
It would have had to have been under the terms of the office. He'd have had to, I think probably.
So this is a cause of action. So it's a cause of action which depends upon the terms of the office, recognised by the law, even in the absence of a contract.
In that context, where it was, of course, agreed between the parties that there was no contract.
Well, that's how the point arises starkly.
Of course.
Did they agree there was no contract, or did they simply agree there was no contract of employment?
I believe that,
no contract.
that it was agreed that there was no contract. I have read this twice.
396.
I'm grateful.
Thank you.
396 at letter
F.
Thank you.
Letter what?
At letter F.
Thank you.
I was going to just show you a couple of further passages in Lord Oliver's judgment.
Can I be quite sure what the passage is? Whilst it may not establish a contractual nexus, certainly assimilates his position. Is that the bit?
That's the passage, yes. So I was going to pick it up a little above E. There's no provision in the Act of 1929 or 53 which sets up the registrars of birth, deaths and marriages, which compulsively leads to this conclusion of matter of construction. On the contrary, the more natural construction of the salary and other remuneration, which is to be fixed by the local authority under section 13.2e of the Act, is that these words connote a financial reward for services rendered. Again, section 13.2f imposes on the local authority the duty to fix the conditions upon which the office of Superintendent Registrar is held, a duty which, whilst it may not establish contractual nexus between the authority and the appointee, certainly assimilates his position to that of an employee, an assimilation which is strengthened by the power of supervision conferred on the proper officer. Moreover, as was pointed out by Lord Justice Evely in his dissenting judgment in the Court of Appeal, the salary fixed by the local authority under 5 of the local scheme is directly related to the number of hours required for the proper performance of the duties of the office. For my part, therefore, I am persuaded that the true nature of the salary for which statutory provision is made is that it is remuneration for work done and not simply an honorarium for the tenure of office.
Maybe it's a statutory, maybe it's a right under the statute.
Well, it was argued that it was a right under the statute because it was not argued that it was contractual, but that's the way it's put. But what one goes on and sees is that the right of the local authority to set off against the obligation to work and therefore not to pay the salary is treated as being equivalent to the contractual right of set-off.
Mr. Sedley's argument, we can see at page 376, if you turn back there at letter C, and he was saying that the salary had no contractual character, and he links it to the provision in the statute, as I understand it.
So that emphasises the point that it was necessary for his argument to say it's not contractual, Mr. Sedley, because he wished to assert that the payment was the honorarium which went with the office, whatever you did in it. That's the way he did it. It would have been open to Mr. Irvine, as he then was, who acted for the local authority, to say, actually, it's a contractual entitlement.
Yeah, but he didn't.
He didn't. What he did do was to say it's equivalent.
It's like a contract. This is a sort of claim under the well-known principle if you can have a claim if it's like a contract.
Exactly. And what he said was that there was a right of set-off just as if there would have been if there was a contract of employment. That's the way he approached it.
He did, but...
And this doesn't go the full distance of the case, but it shows how the law was changing. And it's interesting to see it applied certainly by Lord Templeman in the context of judges. My Lords, just a few other passages that you might want to sideline. H on page 396. And this is the point my Lord Clark was making. My Lord, it doesn't, of course, follow from this that a failure on the part of the office holder to perform the duties of his office necessarily entitles the local authority to withhold payment of the whole or part of his remuneration. But if that is to be justified at all, the determination of the nature of the salary is the first and essential step. If the authority would have no right of common law to withhold any part of the salary were it payable pursuant to a contract of employment, there's certainly nothing in the Act of 53 which would give the local authority any higher right. And Mr. Sedley sought to assert that there was no right of set-off under a contract of employment in the passage which followed. And then at H, that argument is rejected by Lord Oliver. See much force in these arguments, were it not for principles on which I'm bound to refer, I would, for my part, feel bound to reach the same conclusion as the majority of the Court of Appeal. But the critical point in the case, and the point which in my judgment answers Mr. Sedley's contention, is that the action as tried by Mr. Justice Nichols, which gave rise to this appeal, was an action in which the plaintiff claimed certain sums as due to him by way of salary, and in which therefore he assumed the burden of pleading and proving each essential allegation. Although speaking for myself, I question whether the mere fact that the plaintiff was appointed to his office under the provisions of the Act necessarily precludes the existence of a parallel contract between him and the council for the carrying out of his duties. It has been accepted for the purposes of the present appeal that no contractual nexus exists. Nevertheless, the nature of his remuneration and the terms of his tenure of office are so closely analogous to those of a contract of employment that any claim by him to salary payable pursuant to the statutory provisions and the local scheme made thereunder ought, in my judgment, to be approached in the same way as a claim to salary or wages under such a contract. So
maybe it was simply a claim under the statute.
Certainly, Mr. Sedley, as he then was, made the claim under the statute on the basis that there was an action in debt for the benefits, the emoluments of the office that had been promised to him. And that's how it was put. But the answer to it came in this passage, which I've just shown here, that Mr. Irvine was arguing.
Yeah, but that itself must be as a matter of construction of the statute.
Yes. So that's the passage which explains it. My Lord, it's elaborated at E through to H of the judgment. And I think there's one short passage at, two further passages. Just I draw to your attention 404 D to E. This is on the set-off process, the counterclaim. And then the final conclusion in Lord Oliver's judgment at 406. As I've already indicated, the position of plaintiff is very closely analogous to that of an employee employed by the council under contract of his service, embraces substantially all the incidents normally associated with such an employment, save the power of dismissal lies elsewhere than in the paymaster. In the context of a claim against the paymaster for remuneration for his services, where the claim is has the plaintiff earned the salary which he claims, the analogy appears to me to be exact, and in my judgment, the burden which the plaintiff has to assume in order to succeed in a claim of the statutory remuneration is no different from that required of an employee. I would, for my part, therefore answer the first question postulated in the affirmative. So I show you that case. So it's the first of these that I want to show you.
Has anyone suggested that the employment protection legislation does not apply to registrars?
I don't know of any authority that holds that now. And indeed, the most recent...
Quite the reverse.
Quite the reverse. Certainly, there is absolutely no doubt that they are treated as employees for the purposes of the canon of discrimination law. The most recent case, which has some notoriety, is a case called Le Daly against the London Borough of Islington, which judgment was given by the Master of the Rolls earlier this year in that case, where a woman refused to carry out civil partnership ceremonies. And it was certainly accepted in that case that she was protected by...
That was the case that led to an intervention by Lord Carey, was it not?
The very self-same. No, that wasn't actually. The case that led to that intervention was a different case.
Well, it was in a different case, but Lord Carey didn't want Liddell to happen again.
You're quite right. That's absolutely right. The subsequent case was concerned with what used to be called marriage guidance counselling. It was Relate. It was a different... But you're quite right, it did lead to that, and Lord Justice Laws's judgment on that.
But it was that case, the Adela case, that prompted my question.
Yes.
Because there was no suggestion in that case that any of this legislation didn't apply.
No, certainly not.
And of course the discrimination legislation uses the extended
Exactly so.
worker type definition.
Exactly so.
As of
I
course
think
it must.
Mr. Cavan wanted to say something.
Only because I was informed by those instructing me, my lady, that as regards registrars, they're now deemed to be employees by virtue of Section 69 of the Statistics and Registration Service Act 2007, that very well-known piece of legislation. And of course, my lady was referring to the discrimination legislation.
Yes.
There's an expanded definition
I know.
of office holder, as my
Well, of
lady
course,
knows,
I know.
in Section 10A, and that's why they're covered.
So that's the...
Lord Oliver obviously thought there was a contract.
Of course.
Yeah.
I mean, one can read between the texts. Why didn't you argue it that way? That would have made it easier. But there we are. So that's the first of these. The next that I wanted to show you was a case called Waters, which I'll just take very quickly. I'm sorry, I slightly lost my notes. Just a second. It's tab 38 in bundle 2. Now, this case it covers a slightly different area, but deals with another kind of office holder who has been held not to be an employee. It shows how the House of Lords essentially treated the person as being a sort of employee or a quasi-employee. Facts were these. Miss Waters was a police officer, and she was sexually assaulted by a fellow police officer, but not in the course of duty. Thereafter, she complained, and having complained internally within the police, there were a series of very minor incidents, individually insignificant, but cumulatively leading to her having a nervous breakdown. And she sued the Commissioner of the Police for the Metropolis on the basis that he had a duty of care towards her, even though she was an employer, an office holder, but one which was equivalent to that of an employee. And the argument that was advanced was that the Commissioner for Police did not owe anything equivalent to the duty of care that you would find in a normal incident of an employment contract to her on which she could sue. That these were disciplinary matters, that they related to the office, the conduct of the office, and that therefore an action could not be advanced. And the House of Lords rejected that argument and held that although she was an office holder, nevertheless, she was to be treated essentially as an employee for the purposes of the duty of care.
Well, shall we look for the reasons for that after the short
Yes, sir.
adjournment? Well, we'll rise now and look forward to hearing you again at 2 o'clock.